Hello, everyone. Thank you for joining us for this next episode of the On the Mark Financial Forum and podcast. We have a lovely guest today, Alessandra. Please introduce yourself to the group.
Sure. I'm Alessandra Messineo Long. I'm a trust and estates attorney in New York, Connecticut, California, and Washington, D.C. And I'm a solo practitioner. Started my firm on my own about 15 years ago after practicing in the corporate world and at a few law firms in New York City.
Sounds good. Well, we're happy to have you today. We're big on encouraging our clients to establish a full financial team, and estate planning is a really critical piece of that. So for any of you new buyers who have either worked with us in the past or are working with us now, we definitely recommend this as an important step to building that financial team. So we're glad to have you today. Thank you so much for taking the time to join us. And maybe you can just talk for those who may not be as familiar with estate attorneys and thinking, I think especially the younger generation thinks, oh, when you engage with an estate attorney, you only need that when you're old, right? But that's actually not the case.
No, it's
The point is to start much earlier to plan. But can you just give an overview of what you do as an estate attorney, what the objectives are and the goals are of how to set people up for future success?
Sure, absolutely. And thank you so much for having me. And yes, it is a fallacy that it's only for people that are older or people that have a lot of money, right? So I have my youngest clients are turning 18 years old
Wow,
because when,
good for
you know,
them.
when you turn 18, not to get to the nitty-gritty right away, but when you turn 18, your parents can no longer legally make healthcare decisions for you. So my youngest college clients are the ones that are heading off to college or heading off to their first jobs or trade school, and they need to put their healthcare proxy, their living will, and their durable power of attorney in place because legally their parents don't have access to their money anymore or their accounts anymore if something should happen to them or can make healthcare decisions for them. So
Wow.
that's just, kind of like the easiest introduction, from a young standpoint and doing some of the basic documents. But, overall, like wills, trust, and estates sounds so intimidating, right? But, everyone who's 18 years or older, like, should have a will, and it doesn't matter how many assets you have or don't have. And all these other, basic documents like a healthcare proxy, a living will, a durable power of attorney, and other ancillary documents that you might need to have in place to protect you and protect your family if you are incapacitated in one way, shape, or form. Some of the documents apply if you pass away, unfortunately, and that is the will and any trust that you might create, but the other documents are to protect you while you're still alive. And that's really important because if you're in the hospital from a car accident or a slip and fall or something like that, and you can't take care of your day-to-day personal matters, you want to be the one to designate who's going to be able to do that for you, who's the trusted individual, whether it's a spouse, whether it's a close friend, whether it's a parent, whether it's a sibling. So overall there's a lot of different documents that are intimidating to people, but I think the best way to approach it is from an educational standpoint and realize that you do need to put these documents in place to protect you, to protect your family, and protect anyone coming after you. Also, it's also to protect your assets, right? So
Yeah. And can you explain what those documents are? You mentioned a few of them, the power of attorney, the healthcare directive, things like that, just so the audience understands
yeah,
exactly what
sure.
those things are.
Well, the ancillary documents, how I call them, the healthcare proxy is sometimes called a healthcare directive. It basically says that if you can't make healthcare decisions for yourself, you designate who can make them for you. And a lot of times we always request somebody do a substitute or a successor for the person that you name so that you have kind of a deeper bench, right? And, so that if you can't make those healthcare decisions being in the hospital or being a doctor for yourself, whether you've lost capacity in some way, shape, or form, for the long term or for the short term, it could just be that you're on morphine because you got into a accident, or it could be a even more serious situation. You have dementia or Alzheimer's or something like that. You want to make sure those documents are in place before anything should happen to you. So there's the healthcare proxy when it comes to healthcare, and then there's a living will. In some states, the living will and the healthcare proxy are in one document, and in some states, it's in two documents. So, it really just depends upon where you are located and where you live. And the living will is the document that's basically addresses if you are in a vegetative state with no hope of survival and no brain activity, basically. And that is obviously something you can choose to do or choose not to sign, right? It's purely a matter of whether you would want extraordinary measures to be implemented on you if a doctor or several doctors determine that you are in a vegetative state and a terminal state with no hope of survival. So that's very personal. And then the other healthcare document, which I recommend to my clients that not all attorneys do, it's basically a blanket HIPAA, right? So everybody's familiar with the HIPAA form because you have to sign when you go into the doctor's office to release records and things like that. So it's a blanket HIPAA. I call it an authorization of medical records. And you could designate the same person in your healthcare proxy to get medical records in the event that you can't get them for yourself. So they can go to all your different doctors and be able to get all the medical records to whatever doctor that it needs to go to. So that's the healthcare portion. Then the other document that I mentioned was a durable power of attorney. And there are different types of durable powers of attorney, but the durable power of attorney that I'm talking about, it basically applies to all of your, I quote unquote, business matters, right? I call it the business document. So if you are held up in the hospital for a couple of weeks and you can't pay your rent, or you can't pay your mortgage, or you can't get money out of the bank for your children, it designates who can do that stuff for you, who will have access in the matter that you can't access your own affairs and take care of your own affairs. And it's a really important document. It's not a document that it should get in other people's hands, right? Even your attorney can hold on to that document. However, I think everyone should have that document, even if their attorney holds it for them in the case of an emergency. And as I
Yeah.
mentioned, there's different kinds, right? There's a durable power of attorney, then there's springing powers of attorney, and then there's a limited power of attorney. Like in your case, right, you would see getting a mortgage. Sometimes people give their attorney a limited power of attorney just to sign the closing papers.
Right. Got it. And where you touched on something interesting, like let's say somebody's in the hospital, they were in a car accident, heaven forbid, and where do they how would people know where to go look for these documents? So if somebody's, in that state and they
Yeah.
don't know who their attorney is, the doctor doesn't know who their attorney is, how do they uncover these documents actually exist?
Right. Well, clearly if they're in the hospital, hopefully there's somebody with them, or they've notified the next of kin or a close family friend or something like that. And the only way for them to really know where these documents are is for families and individuals to have conversations. So I always tell my clients, the most important thing is you tell those close to you, even if they don't have copies of the documents, tell them where they are. They're in a file or a fireproof safe, or, I don't recommend that they be in the safe deposit box unless, that's where maybe the originals are, because if you do pass away and you don't have somebody else who's an owner on the safe deposit box, then you have to go through probate to get to the safe deposit box. So now my thinking is that it needs to be in a fireproof box or a fireproof file in your home that you indicate to certain people who can get into it either via a key or a combination.
Right. And especially if you live in California, make sure it's fireproof, please.
Right, absolutely. And of course, you can give whoever you've named in these documents a copy of the documents.
Sure. Yeah.
But in the event you don't want to, and then obviously access to the originals, which should be in your possession, you should let those close to you know where they are.
Yeah. Yeah. And my wife and I did this years ago, knock on wood, and we're glad that we did. But we actually have a card. I think the company is called DocuBank or something. And it's a card in like, it looks like a credit card of sorts in my wallet. And so if something were to happen to me, if I get hit by a bus and somebody looks at my wallet, they would be able to see that we have documents stored at a certain location. And those are like just electronic copies, but at least there's some way to notify people.
Exactly. And that is a good point to bring up because there are those services out there, and I think they're going to become more and more popular.
Hmm.
I feel like they're not popular enough, and it still amazes me that the surrogate courts and the probate courts of the world do not, hold all the original wills, right?
Right. Yeah.
But and they require an original will when you have to go through probate. So I think, something like DocuBank definitely serves a purpose.
Yeah, it's just so that people at least have a starting point of where to kind of chase the paper, so to speak,
Yep,
and find out who the
absolutely.
people are and how to reach them and whatnot. So,
Right. And by seeing those, sometimes the attorney's name is on the
right,
documents, right? And the
sure.
address and the phone number. And so that, is very helpful.
And then you open up Google and you're all set.
Exactly,
Mission
for sure.
accomplished.
Good
Yeah,
old
and
Google.
when you're not in a position where you can speak or communicate, like these things are really important to have a way to figure that out, especially if you live in a different state than your family members who might be named in those documents. So,
Exactly. And especially if it's like an accident and you're alone, right? And
right.
hopefully you have ID with you and they can, look for your, next of kin and whatever, but
Yeah,
we are always not always, with someone or, not always does everyone know where we are. So
right.
it's
Yeah.
important.
Yeah, for sure. And even if you are, those people may have been injured to the same
Exactly.
degree. You just never
Along
know.
with you, which is
Yeah.
also a good point because that's why I recommend, especially spouses, to have a substitute person after them because if they're traveling together, then it's important to name somebody who may not be with you at the time.
Yeah. And these things are really important, but these are tough conversations to have to like figure out what would you do in the event of X, Y, or Z happening to you. So I think a lot of people, especially younger clients that we've talked to about this, they almost like don't want to think about this stuff, or it's uncomfortable for them to have a conversation about like if something happened to them, where would their kids go? But the alternative of what would happen is that the state would decide, right? If they
Exactly.
can't, yeah,
Yeah, like they would be assigned a guardian ad litem, and they would have to go through the court system, and the state would decide who then would be their guardian,
yeah,
depending upon close family members or close friends or who would be best
yeah,
suited. But it is, a judge and the courts deciding who is best to raise your kids in the absence of you and not you choosing. So, as
right,
tough as those conversations are, it's better to have those conversations. And listen, no one is going to be the perfect substitute for their own parents, right?
hmm,
Never. And it's a very hard situation and something hard to wrap your head around.
yeah,
But naming who you would like is the best situation rather than a
right.
stranger.
Yeah, for sure. No question about it. And I will say, when my wife and I went through this process, I don't know, probably 10 years ago or so, it was a big relief when it was done. Not because I didn't have to talk about it anymore, but it just felt like, okay, like if something were to happen, we now have all the protections in place to be able to deal with it as best you can. I mean, obviously, it's a unfortunate situation you're dealing with, but in the event that something did happen, it was all sorted out, and at least we had a real sense of just a peace of mind to know that those things are arranged, especially when you have kids. Even without, there are important decisions to be made, but I think a lot of younger people just kind of don't want to think about those things, and so they kick the can down the road, or they don't put a plan together at all. And our days on this planet are not guaranteed. you
No,
know
they're not. And I think if you're stuck on a certain issue, or maybe you're single and you don't know who you would leave everything to, right? Sometimes I get those calls, and some of my clients are like, well, I don't know who I want to leave it to. I have nieces and nephews or charities that I like, and they just can't make the decisions. I'm like, well, it's better that you make the decision, and you can always change it. None of this is, unless it's an irrevocable trust, and even irrevocable trust can be decanted to a certain extent, but most of the things that are going to be put in place, you should make sure that they are revocable, or that they can be amended, or they can be changed. That way you can change your mind. So if 3 years down the road or 5 years down the road you change your mind on who should be the guardians of your children, or who you want to give your assets to, or the pet percentages should be different, that's what codicils and amendments are for, to wills and trusts, so that you can change those things. Nothing's permanent, and as long as you have all your faculties, you can still change your documents. And I always tell clients, look at your documents every 3 to 5 years. That doesn't mean you have to change them. Look at
Right.
them and make sure all those people are still maybe alive, and if they're not, that the backup person is the right person. Or is it all saying what you still want it to say, and does it apply to your situation, your
Right.
current situation? Because if it doesn't, then you need to
Right.
revisit it.
Yeah, no, it makes a lot of sense because the people you designate something may have changed with them. And now they're not in a position, for example, to take care of your kids if they're dealing with their own health issues, to where you might need to shift that. And we're going to get into that's going to be a big part of our discussion today, is talking about when to change it. But one quick thing I wanted to ask you about, to clarify for the audience, is the difference between a will and a trust. And what does a trust do? You mentioned irrevocable and revocable, which basically means, can you change it? Can you not change it? If I'm not mistaken, if we oversimplify it, I know there's much more to it than that. But can you just explain what a trust is, and what the difference is between a will and a trust, and why one may be, you know, more comprehensive or valuable than the other?
Well, I'll explain the most common type of trust
Sure.
and will situations. So you can have an estate plan with just a will, right? And a will could have within it testamentary trusts if you have young children, right? So you have let's just say it is a situation where it's a young family, and they've done what's called mirror wills. Everything goes to the husband, or everything goes to the wife, and then it goes to the children. But within those wills, there's um there's ages that it refers to a testamentary trust, where ages the kids can get certain amounts of the assets, right? One third, one third, one third at different ages. Now that's a will situation, and that has advantages in some way, but has very many disadvantages, because it's so simple, and it is more inexpensive to do. However, if something does happen to if you're single and have children, or you and your spouse at the same time, and the kids are then getting assets that are managed by the trustee within the testamentary trust, the court has to oversee that whole process. So even though you have a will, because you have testamentary trusts, the trustee of those testamentary trusts has to account to the probate court every single year, until those kids get their full payout, whether it's 18 years old, 25, 28. It is
And just to
not an
take
ideal.
one quick step back, excuse me, the trustee is the person that you designate to manage the trust if you're not able to manage your affairs, correct?
Yes.
Okay,
Yes,
got
correct. And in mirror wills, you would designate your spouse, and then after your spouse, somebody else. And they would be in charge of the assets that you then leave behind, that you need to then take care of your children, right? So they would be in charge of that. Whereas the guardian is the person who is physically taking care of your children. And it could be the same person. You could designate the same person. But so that's one way of setting things up. And then the other way of setting things up, which is more ideal in a situation where you actually have property, real estate, or minor children, or a situation where you wouldn't want the individuals to get the assets outright, or if you want to protect from probate. So the other situation is what's called a pour over will and a revocable trust. So that works in, you have a will, but it doesn't contain all of the details of the trust, right? So the will actually basically says, I give everything, to my trust, my such and such trust. And the will pours over into the trust, but you still need a will to basically say that, right? And then the trust will have all the details for the most part. I mean, the will still say who the guardian of your children are, who gets your tangible personal property, but it will say all of my assets go to my trust. Now, with a caveat, you need to actually put them in the trust, but that's a whole nother conversation,
Right.
and title them into the trust. But that is, a more ideal situation when you own real estate and you have young children, because then you can avoid probate. Because if you have assets in a revocable trust, that is not a public document, number one, and it's also not subject to the probate court. So the trustee can manage your funds for your heirs without having to account to the probate court for every single cent, unless the trust basically says you have to do an accounting to the court every, which a lot of them do not. And by law in certain states, the beneficiaries could demand an accounting, or demand an accounting every 3 years or something like that. But
Hmm.
it's not as onerous or expensive than having to do it every single year,
Right.
which can be very expensive. And not to mention that the probate court charges its own fees
Sure.
to probate a will and to obviously oversee
Right.
an
And those
estate.
fees are pretty high, right? I mean, I've heard tens of thousands of dollars for an estate that
Yes.
didn't have a will or
Yes.
a trust.
Yeah, so you're actually, you have to pay taxes, number one, you have to pay the probate fees, and then you have to pay for the attorney to guide you through the whole probate and do all the filings. And then on top of it, depending upon what state you are, it could take anywhere from a year to 2 years to 3 years to 5 years to probate an estate, depending upon what state you're in
Right.
and how many assets you have, and and assets that have to go through probate. So the ideal situation is to really do, in a majority of the cases, the pour over will into the revocable trust, and then title your assets, as many as you possibly can, into the revocable trust name, or make the revocable trust the beneficiary. And then, of course, there are certain assets that you can't do that, but that's another topic.
Right. Yeah, and like I'm very transparent on this podcast about what I do. So like if you looked at my bank account, it would have the name of the trust as the owner of the account. Same thing on the title to my home where my family lives. So you can put those assets pretty easily into a trust. Lenders like us, allow it all the time as long as there's nothing abnormal about the trust that might prohibit the lender from foreclosing or something like that. But
Exactly.
it's a great way to make sure that your assets automatically transfer. So it sounds like the main difference between having a will and a full trust of some sort is the cost may be less for the will, but it doesn't have much detail in it. And the will is potentially subject to court confirmation or at least involvement to some degree when decisions are being made, and that can hold things up and cost you money and things like that. So the trust definitely seems like it's the way to go. If people are going through this process, probably better to not go halfway.
Assets that you don't want to go via contract, meaning that doesn't have beneficiaries on it already, and you wish them to get those assets outright to the beneficiaries, a revocable trust may be the answer for you on those particular assets.
Got it. Okay. So let's shift the conversation a little bit to life changes, things, we talked about one, how, the benefit or the people that you designate, their health may have changed, or, different reasons why it might be a good idea to update the trust every year, 2, 3 years, whatever it is. What sort of family situations or health situations would you recommend that somebody look at their documents again to make sure that they're still accurate and consistent?
Yeah. Well, you definitely, nailed it there. Health situations, if you've named anyone in your documents and they're starting to get old just because they are, right? And, a lot of people, might name their aunt or their uncle or their parents, right? And their parents are reaching 80 and they still might be healthy and they still might have their facility, but they're not getting any younger. So it's probably better to change that while you can, especially if you have other people that who are younger that you can trust and change. So that's one situation. The other situation is if you have lost your spouse, or and you're a widow, that would be reason to change your documents, because then you may want, it's a good time to update them, and because most of the time you will have named your spouse as the first person in all of these things, and then maybe when you did your documents your kids were younger, so you would never name them, and maybe now you have adult responsible children that you want to name, right? The other thing is obviously when you have children. So if you have done an estate plan at all while you're single with no children
For
and not
you.
married, good for
Good for
you.
you. Yep.
Exactly. So if you get married or if you have children, then you should definitely update your estate plan. And obviously, if you have a prenup or any of those things, you should take that into consideration, but you should, update your estate plan with regards to that. Also, the other thing is obviously any type of dissolution. So if you've gotten divorced or in the process of getting divorced, then you should look at your estate documents and see how they need to be changed.
Right. And if they should be separated at that point, where each
Right.
person needs to have their own.
Exactly. And once the divorce is final, you definitely need to have new estate documents,
Yeah.
because, obviously everything considered each other. It's very important depending upon, and different in every state that you live in. Some of the estate documents can be changed while you're going through the process of divorce. So you can change your healthcare directives. You can change your durable power of attorney in some states, but you might not be able to change your trust or your will until you're actually divorced. So you have to keep those things into consideration. So I
Yeah.
often tell anyone going through a divorce to consult with an estate planning attorney.
Yeah, for sure. Because if you're if you've designated that person as your healthcare contact, the person making decisions for you, and you're not on the greatest of terms, I'm not sure. You never know how those decisions will be made, but maybe not in your best interest when it's
Right.
somebody that you're not on good terms with. So
Exactly.
yeah,
Yes.
definitely want to update that.
Absolutely.
Now, what
Absolutely.
about if somebody comes into, let's say, an inheritance, or they do a scratch ticket and
Yeah.
win millions of dollars?
Yeah, that's a
Would that be
reason.
another time?
That's definitely a reason to relook at your estate documents, because then at that point you might, if you're fortunate enough to be inheriting money and it's not in its own trust via your parent or your aunt or your uncle or whatever, if it's something that's going to be outright to you and you need to create a trust in order to protect it, then you should do that. And it, at the least it should be a conversation, and if you come into money like, lotto winnings that you didn't anticipate, well then you probably need a more sophisticated estate plan than you had before, because you have to consider tax ramifications and figure out what you need to do, because there are, estate tax limits that have to be considered, and gifting and things like that, to make sure that you can have, leave whatever to whomever without, stiff estate tax penalties.
Yeah, and that's definitely something I want to get into as well, because I know that there are, and you would probably know them better, and I know you're not an accountant and neither am I, but there are some tax advantages to setting things up a certain way, or to even potentially having a trust. Can you talk to that? Like, how do you engage with your clients, or do you pull in an accountant to have those conversations? But they're especially when it comes to estate tax, and when you pass away, what happens with your estate, and is it taxable, all those types of things. Can you just kind of touch on that piece of it?
Yeah, of course. Yeah, it's very important. And I think you touched on this earlier on that we all work together, right? All your professionals work together, whether it is your mortgage professional, whether it's your CPA, whether it's your financial advisor and your attorney, because we want to make sure all the pieces work together to be as tax efficient as possible. The CPA is an important piece of the puzzle when it comes to someone who is up against potential tax ramifications, and trusts are a great vehicle to help in that manner. I mean, revocable trusts themselves overall do not quote unquote save on taxes or save on estate taxes. However, there is language in most revocable trusts that say that the trustee can do what they can possibly do together with professionals to change things or invest things or do what they need or gift in order to save on taxes. So that's important language to have in there. And then there's a whole series of different types of other types of trusts, irrevocable mostly, that save on taxes. And there are, as I mentioned, lots of different types of irrevocable trusts. There are, yeah, and they all have acronyms, GRATs and SLATs and charitable annuity trusts and charitable trusts and family trusts and, blah, blah, blah. So there's a lot of different names of trusts that are very intimidating, but they all have different pros and cons to them, and can protect your wealth to a certain degree, or protect a piece of property or what have you. But in some of the circumstances, you're giving up some control to a trustee other than yourself, and you may be giving up some of your wealth and passing it on to the next generation. So you need to really understand what these vehicles do and what you're saving as a result of doing them, and what the next generation, is saving as a result of you putting them in place, um, and um, and what control you're keeping and what you're giving away.
Yeah. Well, it's a really important topic because taxes are, I think people underestimate it because you don't think about it until the last minute. But if you're doing proper tax planning, whether it be related to your estate or really almost any financial move, we talk about it with clients who are thinking about, well, should I take out financing or not? I mean, there's a number of different situations. I won't get into each one, but the tax planning is really critical. Looking at capital gains tax if you're selling a home versus, waiting until a senior passes away, for example, in which case they might not pay any capital gains.
Exactly.
There's a lot of little details that if you don't have the proper financial team, you're never going to know. And we had this situation come up recently where a 97-year-old woman sold her home to pay for care, and she probably had 6 to 12 months left to live, and she probably wrote $1 million check to the IRS for no reason, just because it didn't know. And that's partly why we do this podcast, is to just bring information out there. I mean,
Yeah.
if somebody picked up that tidbit from one of our conversations that we've had on the podcast over the years, mission accomplished. It makes it worthwhile to do every single episode we've ever done to get that one
Right.
tidbit of information. So
Absolutely. And
yeah,
there's lots of different ways to, be able to pay the estate tax if you can't protect everything too, like purchasing insurance policies that could then pay estate tax. I mean, obviously you want to work to minimize the estate tax as much as possible, but there's, dealing with a good handful of professionals is really worth it
it is.
because they can give you ideas.
It is. And I think with estate planning in particular, I know we talked about this briefly, people think it's only for rich people and it's only for old people. And
Yeah,
it's really not. I mean, you gave a perfect example right when we started of an 18-year-old that needs it because their parents can't make those decisions for them anymore. I didn't even think about that. My daughter's 14. I got to get to work.
we have a few more years, but
Yeah,
you
we
have
got
to
a little
remember that.
time.
Yeah, you have to
We got
remember
we got
that.
to make sure she can brush her teeth first before she runs out the door to school,
Right.
or that she actually wakes up from her own alarm clock as rather than me being the alarm clock. But it's just steps in
Yes.
the right direction.
Which reminds me, I have a 17-year-old, so it's about time soon
There
for
you
her to
go.
to get it done.
Well, we all need to remind each other to do these
Hmm.
things.
Yep.
But we always end these episodes with one question. I'll be curious to hear what your answer is to this. Don't worry, you don't need to stress over this question. But if there were one thing you could tell people that you want them to do, or you just say, God, I wish everybody knew to blank, what would that thing be?
I would say that it's I don't know. That's a hard one because there's quite a few things I would say, but
Right.
I
Let's just
really
keep it
think
real basic for somebody that doesn't have a plan. They don't have
no,
an
I
estate plan
really
or
think
anything.
that, for someone that doesn't have a plan, at the absolute basic, you need to have a will, a healthcare proxy and living will, and a durable power of attorney. You have to have those things, even if they're not the best, like that you need to have those things. I also would highly recommend that you have them done by a professional estate planning attorney because they know what the provisions are. They know how things have changed over the years. They know, will get to know your family and your situation to put in place what you need that's best for you. Like a lot of people will come to me and be like, well, my friend told me this, or my friend told me that, and blah, 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 blah. Everybody's situation is different. Not that you shouldn't take advice from your friends, absolutely, but make sure that then you speak to a professional about it. And I just think it's so super important. And as you might find, and like you don't know what you don't know. So let me just take Connecticut, for example. Connecticut and New York and California and DC practice in four completely different states that the laws are different. Now, in Connecticut, even if you own a home joint with right of survivorship, you need to put that home into a revocable trust because if your spouse dies, you still have to go through probate to get clear title to the home. In New York, you can get clear title to the home by showing a death certificate to the title company and
That's
having them
simple.
change it.
Yeah.
So it's very different. So just consult with a professional and get those, crucial documents in place. Then if you want to do something more sophisticated for tax reasons or because, maybe you have a special needs child or something like that, then you can cross that bridge.
Right. Or even just a family member that's special needs that you want to help, by
Exactly.
designating some of the funds or, yeah.
Hmm.
Well, I think one of the reasons that people don't necessarily do this is they're worried about cost. So, and I'm not asking you to disclose your specific fees, but just to give people a ballpark range of a very simple will or trust plan, just bare bones. What's the range of costs for those types of services, if you had
Well,
to
what
guess, from an
what
average
I've
attorney
seen,
again?
clearly it depends on the state because, it is going to be completely different in Idaho and Nevada than it's going to probably be in New York, or Florida or wherever. So I think there definitely is a range. I think there, is a fallacy out there that it should be cheap. And, but in my mind, I don't think it's cost prohibitive. I think you can get a decent will, not a whole plan, but a decent will in place for $1,200, $1,500. But if you want all the ancillary documents with the will, then you're talking somewhere between 2,500 to 3,000 for a single person, and maybe with spouses, you can find a lawyer that does maybe a flat fee and, pay 3,500 or 4,000, but I'm talking Northeast, right?
Sure.
Might be cheaper elsewhere, might be more expensive in California. I don't know. Right. But, and the going rate for lawyers, if they're charging an hourly fee, is all over the map, depending upon where you are.
So it really varies, but if you think about what the implications are if you don't have a plan, I mean, just the cost of probate alone is
Probate
10.
alone, yeah. probate alone to give a retainer to an attorney, it's at least $2,500, $3,500. And then, even a simple probate, is 15, $20,000.
Right.
So, not to mention, the fees to the probate court, and the red tape and the headache and the time you would have to take off of work. So you have to think about the opportunity cost. So the money that you spend on the actual planning and the documents is literally a fraction of what you would spend if you didn't have those documents in place, or what your family would spend having to go, to an attorney and jump through hoops and go through the probate court or petition the court or pay a guardian ad litem or whatever the case may be. I mean, literally is a fraction.
Right. And it's not just the cost. It's imagine your family's going through this trauma situation at the same time. And now you're putting them through the court system where they may not be able to resolve your matters if you're not around, for months at a time. And if you have kids, for example, they might need that money to live off of. And, it's really, the implications are high. And I think especially when you have kids, if as a parent myself, I feel like it's a responsibility. You need to do these things because you need to think about the hard things to think about, the uncomfortable things that you have to figure out and determine. You have a responsibility to take care of your kids in that way. And I'm a big proponent of this. This is why we make sure that our clients know that this is part of the financial team that you need to have. Even if you're, I guess, as young as 18, that's something I learned new today.
Right.
But
Right. And
it's just so
it's also
critical.
a cost that is not reoccurring so much, right? So, it's not like your insurance bill that you pay every single year, right? If you can get these documents in place, you spend the money because it is insurance, right, for you and your protection and your family's protection. But then you might not have to update them for 5 years or 10 years or 15 years,
Right.
so, and the cost may be cheaper when you update them, or, you may have to redo them altogether. But it literally is a drop in the bucket compared to what it would cost you if you have to go through the court system.
Yes. So my word of advice, which I think you're echoing currently, is don't be foolish and not spend the money to do this. Do something, even
Yes,
if you can only afford the bare bones, it's going to be far better than not doing anything, not having anything in place.
absolutely.
Yeah.
Absolutely.
All right. Well, I really, really appreciate your time and expertise on our call today. This was really helpful. I think we're definitely going to be helping people, and that's the goal here, is to get good information out there to the people that need it and those who need it most. So this is not only for rich people, it's not only for old people. Get on it early, and don't take that chance that you might find yourself in a really bad situation that most of the time when those bad situations happen, they're unplanned. So you need to plan ahead for the unplanned. So, Alessandra, thank you so much for joining us. I know we'll be engaging more over time for sure, but I appreciate your time and sharing your expertise with everybody. And if people do want to find you, what's the best way for them to reach out?
Well, thank you so much for having me. This is a great conversation, and I really appreciate just sharing the education and the knowledge. And to reach
Absolutely.
out to me, they can feel free to email me at aml@amlonglaw.com, or go to my website, which is www.amlonglaw.com. Number is 203-249-3601. So, or you can Google my name.
There you go. Yeah,
There
good
you
old
go.
Google.
Yeah.
Don't do your estate plan on Google, please.
Do not do your estate plan on Google. Please do
Right.
not.
Just
Or
Google
AI.
her name and you'll be in good hands.
Exactly. Well, thank you for having me.
Of course. Thank you so much for joining us. And thank you to the audience for joining this session of On the Mark. And we'll look forward to seeing you next time. Take care.
Take care. Bye.